what a treat to be back home in many respects. Since I'm batting leadoff, I thought I'd start with a joke, but so many topics are out of bounds. Politics, religion. So I thought a math joke might be appropriate. I have 2 young kids, they have lots of math jokes. And I was thinking about telling one about the concept of infinity, but there was no end to the joke. The concept of infinity is entirely appropriate when we talk about problems with the criminal justice system. Because even though the title for this event is Writing Wrongful Convictions, even if we manage to write most of them, all systems devised by human beings are fallible, so there always will be mistakes. The goal of all of us, and in fact many of you out here, I know Stacy and others, is to make it as accurate as possible, to balance fairness with accuracy in a way that's appropriate. So what I'll do during my short time, 10 minutes I promise, Dean Kaplow, I'll talk briefly about the history of wrongful convictions and then about a couple things that we've learned about that history before Adele and Lisa and Lori and Glenn take it from there. So in thinking about the history of wrongful convictions, first a definitional moment. The phrase wrongful convictions could mean a host of different things. It could mean any conviction that's tainted by error. Maybe an error based on a constitutional violation, unethical behavior by prosecutors, a jury mistake. But the phrase as used in the legal community relates to actual innocence. It's actually a bit of a misnomer, and it's a source of controversy in the literature. We use this phrase wrongful conviction, which in fact is broader than the universe of cases that we really mean. We're really talking about the innocent man or the innocent woman who's convicted, who's factually innocent. He didn't do it, she didn't do it. The history, I think, can be divided into 2 periods. First, the historian in me, the frustrated non-PhD student, right? I get to talk about history. 1819 to 1989. The first documented exoneration of an innocent person happened in Manchester, Vermont. Have any of you been there? Bucolic, great town, right? There's an independent bookstore, North Star Books. It's a great town, okay? I don't think the bookstore existed back in 1819, when 2 brothers, the Bourne brothers, were exonerated under very curious conditions. Back in 1812, they were farmers. Their brother-in-law went missing. Russell Colvin went missing. Now, immediately when a brother-in-law is dead, you, of course, suspect the in-laws, right? That by definition, okay? Especially in a rural community. So the Bourne brothers were convicted of capital murder. They were sentenced, and they spent 7 years on death row in Vermont. Until, lo and behold, Russell Colvin walked back into town. He had never been killed. He just went on the lam. And I think I might have done so had I had 2 brothers-in-law, like the Bournes, okay? That's an easy case, right? You're convicted of killing someone who actually is alive. Great case. Have you guys ever had that case? I would love that case. Hasn't happened. After that case, it was incredibly difficult to prove innocence. How do you prove a negative, especially in the absence of science? You prove it by finding new witnesses or getting recanting witnesses. And that's incredibly difficult. In the 1930s, a Yale law professor named Edward Borchardt published a book called Convicting the Innocent, where he painstakingly documented 16 cases that he characterized as miscarriages of justice. But it was all based on what we would now call soft evidence, circumstantial evidence. The person was probably not there. Someone else must have done it. Many people remained skeptical, including, of course, the best name in the history of the law, Learned Hand, the worst judge, but the best name, right, from the Second Circuit, who had this great quote in the 1920s in a case called U.S. versus Garson, saying that the dream of an innocent man is unreal. It doesn't exist. It's an unreal dream. The system, I'm paraphrasing a little bit here, the problem without notes, the system is haunted by the specter of the innocent man convicted, and it's an unreal dream. In the 1980s, things began to take off. Even before the emergence of DNA, there was a high-profile scholarly dispute. And I use the phrase high-profile and scholarly a little bit like jumbo shrimp, okay? A high-profile scholarly dispute, like 10 of us know about it. But there were 2 scholars, Mike Radelat at the University of Florida, a criminologist, and Hugo Adam Badow, a philosopher at Tufts, who found about 350 cases that they claimed were wrongful convictions. And then a bunch of other scholars on the right, conservative side of the spectrum, Paul Cassell, one of my former colleagues at Utah, and Steve Markman, deconstructed the Radelat-Badow study and got into, as I said, high profile is maybe not the right word, but at least in our world, a high enough profile pissing match, that's the technical term, over whether or not these cases were ones of innocence or not. That debate, which reached its apex in 1987, really showed the problem. How can you prove innocence? How can you prove a negative? If someone is presumed to be innocent and then they're found guilty beyond a reasonable doubt, that conviction is affirmed on appeal, and you've lost through the collateral post-conviction process, how much evidence is enough to prove beyond a shadow of a doubt that they're actually innocent? Incredibly difficult, both philosophical and pragmatic question. The second era, 1989. That's when DNA technology had finally reached the criminal justice system. And as you all undoubtedly know, what DNA can do is it can pinpoint with virtually 100% accuracy, the biological source of certain genetic material. Blood, seminal fluid, saliva, now even skin. You can identify its source with tremendous precision. That, of course, was a wonderful tool for the criminal justice system. On the one hand, police could now solve the cold cases. You could use DNA evidence to test a rape kit and determine whether or not it belonged to a particular perpetrator. And from the defense side of the perspective, you could use DNA to free the innocent. You could test that long recovered and preserved rape kit and exclude the person who was convicted. In 1989, there were two cases that jostle for the claim, dubious claim, I guess, of being the inaugural exoneration. One, the one that's most often considered to be the first, occurred in Illinois in August 1989. A man named Gary Dodson was freed for having raped a young woman in the Chicago area. Unfortunately, that case is a very strange case. It involved a fabrication. There was actually no assault. It's a very dubious case because, of course, rape allegations are very rarely made falsely, and it's always troubled many of us in the community that this incredibly significant case involved a very rare false allegation of rape. The other case that's often considered to be up there with the Dodson case occurred in August 1989, where a man named David Vasquez was exonerated for a rape, but it was an indirect use of DNA. DNA excluded another man who'd been convicted of other factually analogous crimes, and the FBI concluded that most likely that other man had also convicted the crime for which Vasquez was convicted. There was no evidence left in the Vasquez case. Since 1989, what's happened? Let's talk about the lessons before I wrap up. We've learned two things. With 349 documented DNA exonerations since that period, we not only have freed that relatively huge number of people, but we now have a data set to study and to deconstruct and to figure out what went wrong. And if we can figure out what went wrong in the first place, we can avert these injustices in the future. And as my friends and panelists will discuss, and we'll discuss during the Q&A, there are several very clear factors that appear time and time again in these DNA cases. First and foremost, eyewitness misidentification. A good faith witness who simply gets it wrong. False confessions. An innocent person who, because of interrogation practices, actually makes a wrongful confession of guilt. The use of flawed forensic science, either dubious forensic science, namely incredible or unreliable science, or forensic fraud. The use of incentivized witnesses, informants, jailhouse informants. The use of, police or prosecutorial misconduct, most often Brady violations, the failure to disclose exculpatory evidence. And last but not least, we've pointed the finger at the government. Of course, defense lawyers are often to blame due to ineffective assistance of counsel. So those are the factors that we've identified in the last 25 years and that many people in the movement are working on to right wrongs. The second and last thing I'll talk about is we've learned about the procedural flaws in the system. If, in fact, our appellate and post-conviction system is designed in part to correct error, one thing we know from the DNA revolution is it's inadequate. It doesn't work. First, the direct appeal is a poor mechanism for reversing injustices because of the preservation requirement. You have to preserve issues at trial in order for them to even be addressed on appeal, and also because of barriers against presenting newly discovered evidence and the so-called harmless error doctrine. A lot of these cases later overturned through DNA were presented at the appellate level, and errors were recognized. That was a Brady violation. That was another type of violation, but the court decided that the error was harmless and affirmed the conviction. we've also learned that the post-conviction process, the collateral process, is also deeply flawed. So over the next few minutes, I guess now maybe an hour, we'll probably look at both those substantive and procedural factors. So that's an overview, I hope near enough to 10 minutes to satisfy my master and mistress, Dean Capua. Thank you.